This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. Thank you. I'm Catherine Eaton, a member of the Florida Academy of Collaborative Professionals. And today's guest on our podcast is Jodi Colton. Jodi is a graduate of Harvard Law School and a partner at Brinkley Morgan. Her practice exclusively focuses on complex family matters. She is a Florida Supreme Court certified mediator and a trained collaborative lawyer. She believes that most family cases can and should be resolved without protracted litigation. She currently serves on the Palm Beach County Bar Association's Unified Family Practice Committee, the South Palm Beach County Bar Association's Professionalism Committee, and the Equitable Distribution Committee for the Family Law section of the Florida Bar. So welcome, Jodi, to the podcast. And I'd like to start it off by asking the question that I ask all of the guests. How did you get involved with the collaborative law process?
Hi, Catherine. Thanks for having me today. Um, so, I was thinking about that, and it's been quite a while. I learned about collaborative law very early on as an attorney, um, before I was even practicing family law, and it sounded like a good idea at the time. And then as my practice moved from commercial litigation, which is where I started, into family, I took the training and began, sort of a slow start into getting more involved in collaborative. But I've always found it appealing because my background, even before I became a lawyer, was that I was a mediator. And I was trained to mediate in my first year of law school and started mediating then. And so my mindset, I think, as an attorney, it was always grounded in interest-based negotiation and the benefits of trying to, work on a resolution for people that made sense to them and that met their needs. And that's kind of the for me, the primary selling point of collaborative is that it really helps people get to a result that's actually what they want, and that they can kind of help determine that themselves. And so for me, it was, as soon as I learned that collaborative was a possibility, it sounded like a great idea to me.
So you spoke that your initial background as an attorney was in commercial litigation.
Mhm.
So I know the answer, but I'm going to ask you the question, how does that then parlay into family? Because people think that they're very different areas, but can you talk a little bit about how your experience as a commercial business litigator, and then now moving into family, how there is some overlap and how that knowledge is really helpful?
There definitely is overlap. So I think family law is a hybrid of all kinds of different things. There's the usually the divorce underlying it, but then people may have real estate interests or business interests or other assets that are unique or complicated. And so we end up, or they have trusts and estates and other kinds of things. So I feel like as a family lawyer, you end up learning lots of different practice areas. And I think it's been really helpful to have a foundation in I did a variety of different things for the first, 7 to 10 years of practice before I switched exclusively to family law, which I've been doing for a really long time now. But it I think it definitely gives you a good perspective, and helps you. I think it helps a lot too with drafting agreements, because you have kind of different, you see things maybe through a little bit of a different lens, than if you've only done a family law practice.
And then why did you transition from the commercial business litigation into family? Is that
It's a good question. Why do any of us do this? So as I said, I think when I started law school, I wasn't actually sure I was going to end up being an attorney. I was really interested in alternative dispute resolution and conflict resolution. And so I had that kind of different bent about, helping people solve problems as opposed to litigating and fighting with people all day. And I think commercial litigation is not as people focused. And so some of the work I was doing early on, there weren't my clients were companies, not people. And I rarely ever spoke to the person who was actually directly affected by it. And I think I really miss that. I really like family law, working directly with clients and helping people try to get to know people, figure out what's important to them, and then help them get there and help them get from one point in their life to another point in their life. I just found that more sort of satisfying and more engaging than what I had been doing before that.
And then will you talk a little bit about the collaborative process? Because you just touched on helping people to resolve it. And so explain how collaborative is different and in helping people to resolve in especially in a family situation. Explain to the listeners what's different about collaborative.
Okay, I'm going to try. So I think for me, the way I see it is most people think if they're getting, that they're getting divorced and they need to get out of the marriage they're in and into the next stage of life. And there's more than one way to get there. The traditional path is plaintiff versus defendant, one person versus another person, adversarial, you're suing your spouse. Collaborative is a totally different mindset. It is you and your spouse are going to sit down at a table and solve your problem and work it out and figure out a resolution. You may not like all the parts of it. It may be painful. It may be difficult. It's not necessarily emotionally easier than a traditional divorce, but it's a totally different mindset of how you're going to get from point A to point B. And I think it's so much more effective and productive for solving a family issue than the other alternatives. Even than mediation without attorneys, which I think sometimes people think is the route that they would, if they're not litigating, then they can mediate. And I think collaborative is almost like a hybrid between those two things that um, solves some of the deficiencies in a mediation alone, and a lot of the deficiencies of a litigation process, which is, I think, the most inefficient, unpleasant possible way to get to the end of your divorce.
And you're trained as a mediator. You shared that you were
I
trained
am.
as a mediator. So talk a little bit about, I don't think people realize that most of the collaborative professionals also are trained as
Mm-hmm.
a mediator. So speak a little to how that training as a mediator is so helpful in the collaborative process.
Collaborative is about um, figuring out what's important to you, what you want to accomplish, what your goals are, what your objectives are, and then having a team of people support you to get there, and to get both parties where they want to go to the extent that we can, to the extent that we can find common ground, maximize the benefits for everyone. And people talk about that as interest-based negotiation, which is the same training that mediators have. Most mediation training and most mediation skills are really about the same skill set of figuring out what's important to people and helping them find common ground and find places they may not even realize where they agree. And I think that skill set of working on focusing on what's important to you and not what your position is. I want that couch, I need that couch, versus, well, why is that important to you? Well, it's important that we have a place that my kids are comfortable and familiar with, and they've always had that couch and they love that couch. Well, okay, so why is it mattering to you? Why do you care? I think that's kind of the mediation skill set that the collaborative team brings to the case. We're all focusing on what are we trying to hear that underlies the first sentence that someone said.
That's a good explanation of it. Talk to me a little bit about your experience of how long the collaborative process takes.
Mm.
I mean,
So
people say, oh,
it's
that it
faster.
takes too long, but
It doesn't take too long. I can tell everything. So when you're getting divorced, everything is too long, right? Everything takes too long. Everything is because it's uncomfortable, and no one wants to be uncomfortable and feeling uncertain for any length of time. And it's that emotional unrest is a big part of it. I think every divorce is going to take a certain amount of time to just for everybody to figure out what they want, to figure out what they need to address, and then to start making good decisions, because you can only do so much so fast. So I think part of what people want to rush through their divorce, and then they get to the end and they didn't think it through. They didn't really have time to process. I think collaborative gives people an opportunity to move at a pace that fits them. So some people do want to go more quickly and some people want to go more slowly. And I've had some collaborative cases. I have one now that's been going on for a few years because the people chose to pause. They decided through the collaborative process that what they really wanted to do was wait a year because there were some other circumstances in their life that they both agreed they wanted to attend to first. And so we paused and we're going to resume it later, with an understanding that that's the plan. And I think, that worked for that family. Other people say, okay, I want to be done in 2 months. Well, maybe not. But I think the pace is much, you have much more control over the pace than in a litigation where you have absolutely no control. And it could go on for any number of months and it's never shorter. I mean, a litigated case is never going to take less time than a collaborative case.
That's the truth. People just don't realize that.
It just, yes.
So, um, talk to me a little bit about having control because in my experience, when you go to court, people think, oh, they can just tell their story to the judge and the judge will understand what a great spouse they've been and how they deserve this or that. And they don't realize what it takes to tell their story to the judge. But I would like to, but they see it on TV. So,
Sure. And it's not like that. I just yesterday evening got a court order in one of my divorce cases asking us to come in for a case management conference because we have a new judge and it's our third judge. And the case is set to go to trial in a few months from now. And so to the extent that the people might have told their story to the first judge or the second judge, now you have a new judge. And this judge has never had any experience doing family law of any kind. They have no knowledge of the law. They have no prior experience practicing family law, new to the bench, only practicing for about 9 years as an attorney and not doing anything remotely like this. So that person has your entire fate in their hands. And that is, to me, genuinely frightening. They don't know the law. They don't know you. They don't know your story. And they're going to give you a very short amount of time to try to explain your entire life, and then make a decision. And they are, dealing with many things at once, and they may or may not be paying attention to that most important sentence you said, and they may or may not see it your way or understand it, and you're going to be cross-examined by the other attorney, and you're going to be interrupted in the telling of your story. And my experience is it's wholly unsatisfying for litigants. I have never had anybody go to court and say, that was great. I'm so glad I chose that. I've just never, ever, ever, ever heard of anyone feeling that way. I have one exception, which is a very unique circumstance. But usually it's not effective for people feeling like they've been heard. It doesn't accomplish that.
and in your experience, cases that come or that are coming to you, how do even if they don't choose collaborative, but they start in that traditional litigation mode that we have all seen on TV and in movies, do you find that the majority of them still resolve and settle before they go to trial?
Almost all of my divorce cases resolve before they go to trial, whether they're collaborative or not collaborative. They're going to resolve, but it's what happens, how much time, money, anguish is expended to get to the resolution before the trial.
So if in general, when people are coming to your office and you explain to them all the different ways and they decide, and you know that the end result is more likely than not, they're going to resolve it and they're not going to
Yep.
go to trial. So why do you think people are still choosing the traditional route of litigation versus switching over to collaborative and resolving the matter?
It's a really good question. To me, there are a couple reasons that I see. The two things that I hear the most are, well, I don't want to have to, restart again. If we don't settle, I don't want to have to hire a new lawyer, start again, et cetera, et cetera. I think that one is the easiest one for me to address because it happens so very infrequently. And if we do a good job of figuring out whether it's an appropriate case for collaborative, because I don't think all cases are appropriate or a good fit, um, then that's so unlikely to happen. You're just as likely to switch attorneys in your litigated case because people do that all the time too. So I don't think that's the one I hear that I think is the easiest for us to deal with. The second one is trust. And I do think the collaborative process requires there to be a certain amount of basic trust and a shared goal by both spouses that they're trying to get to someplace fair and reasonable, whatever that may mean to them, and not out for blood. If you're trying to hurt your spouse and win and beat them, and you know this isn't for you, this isn't the place for you, because this isn't a tool for that. It's a tool for actually resolving the divorce and trying to figure out a way forward and solve all the issues that need to be resolved, and figure out your time sharing schedule and figure out what to do with your house and those kinds of things. But if you wanted to use the divorce process as a weapon, then I think that's the place where some people feel like, or they feel like their spouse is going to do that, and so they don't feel like they're going to get a fair, it won't be fair, the process won't be fair to them because they won't be able to counteract that. And so I think that's actually, to me, the tougher one, because I think there are some cases where that's true. I think a lot of times, though, if you have an effective attorney, you can overcome a lot of that because you do have somebody there who's looking out for your interests and who's asking the right questions, and making sure that we've uncovered all the things that need to be uncovered and looked under all the rocks, and that you're not all alone out there. You do have an attorney. And so I think we can get over a lot of things. There can be a lot of distrust that we can get past, even without the litigation context.
Thank you. Thank you for explaining that. And now tell our listeners, if they are looking for a family law attorney and somebody who's trained in collaborative, how can they find you?
Oh, it's easy. So we have a website, brinkley-morgan.com, and I am on there. I think I'm listed in the FACP directory, and